today read about another state securities regulator getting involved in a crypto-related business, and this is this power mining pool and the North Carolina State Securities Commission. And it's important to kind of understand like the interplay between like the federal level with the SEC and your state level Securities Commission. So each state has its own Securities Commission and its own securities law, 43 of which are pretty much the exact same, and 7, which are primarily the larger states like California and Texas, have a nuanced sort of securities regime. But if you are going to sell securities in any of the states, you have to comply with those rules, and a lot of times those rules mirror what the federal level does, right? Especially as it relates to selling securities offerings, accredited investors, things of that nature. Obviously at the federal level there's an intra-state exemption, meaning like when you have an offering that's only between persons of a certain state, then that's exempted from federal registration, but it's not necessarily exempted from state level regulation. So, you know, when you look at like power mining pool is a great example, right? Because it's really like a disguised MLM, right? And you see a lot of these Bitcoin related ones that really take the shape of MLMs. And like an MLM sort of has like this exception under the law to some degree because it can be registered in what most states call a business opportunity, right? Like look at like Michigan, which is like MLL Home. There's a lot of that, right? You can register these business opportunities, and it's this quasi exemption from like a state securities registration. It just doesn't apply because you're selling like a business. You're not really selling a like a security or a pro rata interest in any company. So here with power mining pool, you had sort of like these unknown people, and I think the cease and desist order said that like the people selling it may not even be using the real names and all that, but the reality is they were selling shares. They even used the word shares, and the solicitation was very broad, right? So in order for it to conform with state level regulation or even federal level, is that you would have to sell only to accredited investors. So, and obviously that wasn't going on, nor apparently was there any degree of actual like attempts to verify investors or whatnot. But it's a cautionary tale because just because conceivably the SEC, the federal SEC doesn't get involved, it doesn't mean that you don't have to worry about state level registration. And in most cases there's a state level filing component when it comes to selling securities. Now obviously like in the ICO context that may not apply, right, if you're doing it right, but at the end of the day, like it's something to be wary about. And also when you're talking about stuff like power mining pool, and like I get what they're doing conceptually, it makes sense, but they're not selling it as like a business opportunity, right? And they're not selling it as like a franchise, which would trigger its own rules. So they went about it the wrong way semantically. They did it very poorly, but and at the end of the day, it's not terribly surprising they got shut down, but it's not to say that they couldn't have done it properly. They just didn't do it properly in this case, right? And that's when you're selling like a business opportunity versus what you're defining as some type of security, which any state regulator can get involved in. You've seen this now in multiple states, North Carolina, Texas, and the like. So something to be wary about, and some aggressive states may take different stances, which conceivably the U.S. SEC could take no action, right? So definitely look out for that, and look out for the construct between business opportunity, multi-level marketing, and the sale of securities, because you're likely to get tripped up. So I'm Tracy. I'll talk to you later.